Good morning, America and Brazil, and good afternoon to our colleagues and viewers in Europe, and good evening to our audience tuning in from Asia. Wherever you are, welcome, and thank you for being with us today. I'm Lilla Norakish, Senior Policy Analyst at the Information Technology and Innovation Foundation, and I'm honored to moderate this very global discussion. 1 year after the DMAs being fully enforced, its ripple effects have been felt far beyond Europe. Some jurisdictions are embracing ex-ante regulation to rein the perceived power of platforms. Others are adopting ex-post competition tools, and many are still evaluating the trade-offs. Many ask whether the shift to ex-ante regulation helps smaller firms and promotes consumer fairness, or has unintended consequences such as chilling innovation. To explore these questions, we brought together a remarkable panel of enforcers from around the world. Each of them brings a unique perspective on how digital markets are being governed and how their jurisdictions are viewing different global trends. Let me briefly introduce our distinguished speakers. First, Dr. Alberto Bacchiega. Alberto is the Director for Digital Platforms at the European Commission's DG Com, where he leads the enforcement of the Digital Markets Act. He joined the Commission in 2000 and has worked across state aid and merger control in telecoms, finance, and pharma. Alberto, we are honored to have you with us today. Our next speaker is Dr. Andy Chen, who is the acting chairperson of the Taiwan Fair Trade Commission and formerly served as the TFTC's vice chairperson and commissioner. He previously led Young Christian University's law school as dean and as a leading voice on economic analysis of regulation. Dr. Chen, we are delighted to have you with us today.
Thank you.
Our next speaker is Dr. Philip Marsden, who is the Deputy Chair of the Enforcement Decision-Making Committee at the Bank of England and Professor of Law and Economics at the College of Europe. He previously served as Inquiry Chair and Senior Director at the UK Competition Markets Authority. Dr. Marsden, it's an honor to welcome you.
Pleasure to be here.
Finally, I introduce Dr. Victor Oliveira Fernandes, who is the Commissioner at CAGE, Brazil's Competition Authority, and Professor of Economic Law and Competition Law at IDP. He previously served as Chief of Staff to a Justice of the Brazilian Supreme Court. Victor, we are pleased to have you with us today.
Pleasure is mine. Thank you.
Yeah, thank you. Before we start, I encourage our audience to send their questions on Slido. You find the event code on the website. Now, without further ado, let's start the conversation. As I mentioned earlier, jurisdictions around the world have taken very different approaches to digital markets. Some, such as the European Union and Brazil, have enacted or proposed broad per se ex-ante regimes that prohibit certain platform behavior across sectors. Others, like the UK, have opted for more tailored company or sector-specific obligations. And some, like Taiwan, have chosen not to adopt an ex-ante digital antitrust regulation, instead relying on their existing competition law frameworks. With that in mind, we would now like to hear how each jurisdiction represented on today's panel is addressing competition issues arising in the digital markets. I will start by inviting Alberto Bacchiega to speak about the first year of the DMA enforcement in the European Union. Alberto, the floor is yours.
Thank you very much, Lila, and good morning, good afternoon, and good evening to everyone. So indeed, the DMA has gone live just over a year ago in March 2024, and the DMA it's a law that imposes indeed ex-ante regulation on a very small subset of digital companies, namely the largest digital platforms in Europe. In this year, many things have happened, and the DMA has already started showing positive results. And I would like to mention here a few examples of that. Recently, around mid-March, we adopted decisions specifying how Apple should enable interoperability of its operating system, iOS, with connected devices, things like smartwatches and earphones and the like. And these will greatly improve the situation in Europe for connected devices, for example, to be able to do data sharing, fast Wi-Fi, magic pairing, and all other features that Apple consumers in the Apple ecosystems now enjoy, but people who choose to have devices from different suppliers cannot have in the same way. Also, in the last year, we require both Apple and Google for their mobile devices to open to users the choice of things like their browsers, or for Google, the search engines. And this has resulted in a very important increase of market share for alternative browsers and search engines on Android. For example, Firefox recently communicated that their market share doubled or around doubled in Germany and in France. Another example is about data portability. Users are now in control of whether they want to port their data. This means several things. For example, that if they switch from one type of device to another, they can move things like their files, their photos, their contacts in a much more seamless way than it used to be. But also it means that companies and third parties are in control of the data that they generate on the platforms, and can also ask users for the consent to use their own data, opening new possibilities and potentially new innovative markets. As a final example, I would have more, but I don't want to take too much time. It's regarding Booking.com, which is the latest addition to the list of designated gatekeepers. Now, as a result of the DMA, all over Europe, Booking has scrapped all the clauses that were preventing hotels to offer better conditions to users on their website than they wouldn't do on the Booking website. Some countries already required it, but not all countries in the European Union. Now this is widespread. So how did the DMA achieve this? Most of these things you probably haven't heard so much because they were not the result of a controversial investigation with the Commission opened with respect to the gatekeepers, but actually resulting from the dialogue with gatekeepers, actually avoiding an investigation, but simply, talking to the gatekeepers, say, look, the law requires now you to open up in this way. What is the best way forward? Some of these, for example, the interoperability solution for iOS, are the results of a procedure that is quite novel. It's called the specification procedure, which is not, again, to punish or to sanction or to say that Apple was doing something wrong, but simply says clearly what their duties are and what they have to do in this case, for example, to help interoperability between devices. But finally, no regulation works without some teeth. We also have a number of formal investigations ongoing on a number of things where we couldn't find a solution with the gatekeepers. We couldn't land on the same zone. And that, of course, we have the possibility under the DMA to investigate, to get feedback from the market, to get feedback from the gatekeepers themselves. And if necessary, we will conclude this investigation with finding on non-compliance and possibly also with fines to the companies. I will stop here for the moment. I'm happy to take any questions.
Thank you, Alberto, for this very helpful overview. Now I turn to another jurisdiction where the Digital Antitrust Act has been enforced. It's the United Kingdom. I would like to give the stage to Philip to share his insight on the UK Digital Markets and Competition Consumers Act.
Thank you very much. Well, when I left the Competition and Markets Authority in 2018, I was honored to be invited to join a committee that had been set up by the Treasury to examine digital competition issues in the UK. We had not had really any cases that had failed or had shown us really that delay was a real problem with respect to antitrust enforcement in these markets in terms of cases lost or cases closed or cases missed. But what we had was a lot of economic evidence that problems were coming and problems were already here, and perhaps ex post enforcement wasn't the best way to address all of the problems in these markets. So much like the European approach, we called for a pro-competition regime in this report, Unlocking Digital Competition. with an ex-ante framework for firms with strategic market status. One of our main recommendations, though, was that we needed this kind of ex-ante regulation to be enforced, not just by a competition authority, but by a group, whether within an authority or not, with the right data science and technical abilities to understand whether or not remedies were effective or not, essentially. Especially if we're looking at pro-competitive interventions, the true ex-ante nature of rules beforehand rather than conduct requirements after. The UK regime has both, but a lot of energy has been put into finding out how best to make bespoke pro-competitive interventions for each party, each designated firm when they are designated, and to try to understand the technology behind it. So that's one of the things that takes a lot of time, but on the other hand, that may result in less harm to, or less unintended consequences, we hope. Anyway, our legislation only just passed last year. I mean, it received a royal assent in 2025, actually, and there had been a tortuous process. But when I look at it from the point of view of some of the swings that have been happening politically around the world now, and even back then with Brexit and COVID, I'm amazed that the legislation passed at all. So I'm thrilled. It sets up this ex-ante regime, as I say, that's bespoke. It builds on a couple of very large market studies done by the Competition Markets Authority into understanding the ad tech stack and into understanding mobile ecosystems. And so what I think the UK is mainly doing is, trying to identify beforehand the degree of problems that can be solved with the least possible disruption to the business models of the firms. And we understand that other authorities are taking different approaches. The UK approach is not sort of a general prohibition per se, and there is an efficiency defense, which will be obviously an issue. Full merits appeal is only available if the authority decides to fine. And frankly, I'm relatively relaxed about that, because while a lot of energy was put into debating or not whether full merits appeal was appropriate, and whether or not it is appropriate for a fining case, I'm more interested in the remedies and in ensuring that the digital markets unit within the competition authority is able to come up with solutions to problems and A/B test those remedies and monitor them going forward, rather than necessarily going for fines. And if it's those remedies that are sought, then it's a judicial review standard, which would be less intensive and less repetitive. Anyway, that's an introduction to what's happening here, and I'm really looking forward to the discussion.
Thank you, Philip, for those reflections. Having heard from two jurisdictions actively enforcing a digital competition laws, let's now turn to Brazil, the largest economy in South America, which has previously proposed an ex-ante bill for digital markets and may still be considering this pathway. Victor, all eyes are on you.
Thank you very much, Leila. It's a pleasure to be here. Good morning and good afternoon for everyone. I would like to thank ATAF for inviting me for this, and I'm gonna share with you the key developments in Brazil about the regulation of digital markets. And I think it's important to split this story in two parts, because we have a first proposal that was submitted before the Brazilian Congress in 2022, and this proposal is still going on and is still being discussed before the Congress. And I will share with you more details on this proposal later. But in parallel and at the same time, there has been some discussions in the Brazilian government to draft a new legislation, a new proposal. So maybe you are gonna discuss in parallel these two proposals, but I think it's important for now to emphasize the discussions that has been going on around this second proposal. Over the past year, the Ministry of Finance has conducted an extensive public consultation that gathered over 300 representatives from government entities, business, and academics. And in last October, the Brazilian Minister of Finance has eventually came with a comprehensive report with some findings about this topic. So maybe what has happened in Europe and in the UK with this first round of reports that just happened in Brazil a few months ago in October 2024. That was the first time that there was a report mapping out what are the main shortcomings in the currently Brazilian competition law framework and whether or not we should adopt and complement this legislation with a new ex-ante regime. And the conclusion of this report of Minister of Finance was that we should definitely adopt a new legislation, not to substitute, but to complement the Brazilian competition law framework. And since then, the Brazilian government has been actively discussing the development of this legislation. We don't know right now the concrete details of these legislations, but what seems to us is that the Brazilian government seems to be signaling a preference for a more flexible approach in comparison to the DMA, which would be something more aligned with the UK's DMCC bill, or perhaps even inspired by Germany Section 19A model. But of course, we will only know the concrete details of this proposal when the government finally presents it. But I think that the most relevant part right now is to understand what are the main pitfalls of that first proposal that has been discussed since 2022, and I will talk a little bit of more after about that first proposal. But I think that we are now seeing what are going to be the next moves of the Brazilian government, and we are following these developments with great interest. But I will stop here for the moment, and then I'm going to explain more after.
Thank you, Victor. Lots of food for thought here. Now, I would like to invite Dr. Andy Chen to share Taiwan's experience, specifically with the TFTC's approaches to enforcement in digital markets using the existing competition law without the dedicated ex-ante framework. Andy, the floor is yours.
Thank you, Leila. Thank you for inviting me to this very interesting and important event. Currently, Taiwan does not have the DMA type of regulation, and the TFTC does not consider proposing one in the foreseeable future. Instead, we follow the enforcement recommendation by our white paper on competition policy in digital economy, which we released in 2022. And under the recommendation, we review cases under the existing enforcement framework, but with refined digital enforcement skill and the enhanced understanding of the digital market. And we also rely on a case-driven and a real reason approach, which also emphasizes the importance of local nexus. So under that recommendation, market study or empirical study, especially local market, is quite important. I think I'm going to briefly mention two cases which kind of foreshadowing the release of the white paper. The first one is the Google self-preferencing case in Taiwan in 2015. This involved Google placing its digital map service on top of the page of the search result. And in that case, the TFTC did not find this kind of practice violation of our Competition Act because the market survey indicated that consumer users in Taiwan still has other alternative to get to the website of the target website they want to reach. So it did not create a lock-in effect. The second case is a more recent case in 2021, is the app pre-installation case. And the TFTC reached a different conclusion from that of EU. Again, we also make a market study among the users and app developers in Taiwan. And one of the major findings is that based on the survey on consumer, we did not find a significant what we call the status quo bias by using the Android system. I think this is a main difference between Taiwan and the European Union. And also the app developers here in Taiwan, actually they welcome this kind of practice because that will facilitate their app developer and shorten the time for system integration. So after release of the white paper, we engaged in several enforcement efforts to enhance our enforcement quality, especially in case decisions. So for example, we have proposed the amendment to our Competition Act, which is the Fair Trade Act. And in the revision, in the amendment, we incorporated the authority to conduct general market study. I think this is a very important a tool for us to engage in market survey, especially we emphasize on local nexus in the paper. And also we have actually conduct market survey on the digital advertising market in Taiwan. And we also commissioned several academic research projects with experts and academia to do research on newly emerging issues in the digital market. And we also collaborate with other agencies in Taiwan. We held several meetings with them to understand better the sectors they are under their supervision. I think all these efforts have greatly helped the TFTC to understand the market better and to facilitate our enforcement in the digital market. And finally, I will just mention one case recently, actually last year in 2024, it's the Uber Eats and the Foodpanda merger case. And in that case, we kind of applying all these learnings from our enforcement effort by collaborating with expert academic into this case. So we apply these digital markets characteristics such as the network effect, two-sided market, and also the empirical study finding in reviewing this case. I just want to mention one. During our review, the merging party has presented evidence from other jurisdictions indicating the relevant market should be more broadly defined. The market should include the takeout by consumers as well as delivery by the restaurant themselves. It's a broader market definition. But again, we conduct a market survey in Taiwan, and we found that consumers, especially users of the delivery platform, prefer overwhelmingly on digital platform delivery. So that's the reason we did not accept the evidence presented by the merging party to kind of broaden the market into involving more options for food delivery. So the reason for me to mention the case is that sometimes even in Taiwan or internationally, they may criticize our approach to probably being a little bit lax in enforcement and probably being too lenient on business. But again, I think in this case, because we block the merger, because we found there is an anti-competitive effect, which could not be outweighed by the innovation asserted by the merging party. So I think what is important is evidence and the market study and the empirical evidence. So again, I think the Uber case showcase that even we did not have the ex-ante regulation, existing framework and the enforcement approach based on evidence could still contain any potential anti-competitive from any practice that are occurring in the digital market. I think I will stop here. Yeah.
Thank you, Andy, and thank you all for briefly summarizing the developments in your jurisdictions. With that foundational understanding in mind, let's move to the next topic of our conversation. How do we ensure that digital antitrust regulation stays focused on competition and protecting competition rather than other purposes? For example, while the European competition law protects competition on the merits and uses as efficient competitor test, with respect to the Apple interoperability procedure for connected devices that Dr. Becchiaga mentioned, Apple seems obligated to put any connected device provider in a position as good as its own devices, even if it's less efficient, in a way akin to heavy-handed public utility regulation. How do we avoid this? To get us started, I would like to turn to Philip to ask, how do you see these tensions playing out?
Well, thank you very much. I mean, I think the main question you're having behind there is to ensure that there aren't unforeseen circumstances, in a sense, and there are any kind of harms to innovation or the general direction of technological travel that could be happening. And to that end, as I mentioned earlier, if you're going to have ex-ante regulation, you're going to need to have an engagement, almost a participative engagement, like a regulator does with the regulated parties. And so it's one of those questions where you need to be able to understand the business models. You need to be able to test them to see if they provide the innovative services without the sort of toxic aspect that you may be concerned about from a consumer welfare point of view, or from an entry point of view, an access to the platform point of view, or a fairness of treatment on the platform kind of thing, or an ability to switch platforms readily. These kinds of things are all, I think, areas where the authorities benefit from, as Andy mentioned. It's got to be an evidence-based approach. You've got to have the skills and the technological understanding behind it. And if you're going to be dealing with these large platforms that you mentioned, and ensuring that these kind of remedies can be rolled out in the jurisdiction that you're concerned with, and don't conflict with other jurisdictional requirements, you need to have not only that communication with the firms, with the regulated gatekeepers, so to speak, but also with other countries and other regulators, to ensure that you're learning from one another. And I'm hoping the UK regime will be a bit of a test bed for novel remedies that might address a particular service rather than change an entire approach. But we'll see what comes out. Whatever it is, I hope that the remedy is always proportionate, and I'm sure that will be legally tested as well. I hope that helps.
Thank you, Philip, for opening this wide window to this very important issue. Let's now hear from Alberto. What's your take? I believe you are muted. Alberto, you are on mute. Alberto, I'm sorry, but you are on mute.
I'm very sorry for that. Sorry, I spoke in a minute to myself then. Okay, let me start again. So the DMA goals are to ensure fairness and contestability. That is what is written in the law. Both of these are concepts very, very close to competition. Competition is an enabler for contestability, and is an enabler for fairness, and it is an enabler for innovation. We are absolutely convinced that the best incentive to innovate is because you want to do better than your competitors. And when you don't have competition, there is plentiful of evidence that innovation suffers. And it actually makes a lot of sense. No companies want to spend money in costs when they have a protected market. That really doesn't happen. That's not what drives innovation. That's not what drives our economies. So in the interoperability decision in particular, we specify a few aspects of interoperability. The law says that Apple needs to provide solutions to third parties that are available to themselves. But here we are talking about solutions like having Wi-Fi pairing in the same way that Apple does for its own devices, to have the possibility for people who don't buy an Apple Watch to actually read their emails, to have push notification of the watch of their choice, like they have on Apple. And nothing of this is very difficult, actually. It's all APIs that they simply need to be communicated to third parties, and then third parties do the rest of the job. So I simply don't understand how something like this can impede innovation. Actually, it will promote innovation, because these third parties now, they can actually interact with users, understand what user wants, and perhaps propose something new to users that nobody had thought about before. There is no danger for the system. It is an explicit feature of the DMA that no gatekeeper is obliged to do anything if it threatens the integrity of the system. There are also safeguards regarding security of the systems. So the whole purpose of the DMA is actually to open new opportunities and to open to innovation.
Thank you, Alberto. It is very helpful to hear the European point of view on this topic. Let's now shift the focus to Brazil. Victor, we would love to hear your perspective on how this debate is viewed in your jurisdiction.
Thank you, Lila. So as I said, we did not pass it any legislation so far, but we have been following these discussions from other jurisdictions, and when we look at the only concrete proposal that we have here in Brazil, which is this proposed legislation 2768. It has a lot of problems, in my point of view, because it portrays digital platforms as public utilities firms, as they were some sort of new public utilities systems, and that is problematic, I think, for several reasons. And this first proposal does not does not explicitly state what is the goal of this legislation. So it's not clear for us if this proposed legislation would address worries about fairness and contestability, or if it is still confined to the consumer welfare standard, which is pretty much embodied in the Brazilian current legal framework. So there are a lot of questions that are still open in this proposal that is being discussed in the Congress. On the other hand, talking about the government proposal, those questions are still open, because we cannot state so far whether or not this proposal will leave room for efficiency claims, for example, for defenses based on economic grounds or not. So whether it's going to be more focused on fairness or contestability or not. So those are all open questions that should be discussed soon. But I think that we are trying to follow other jurisdictions and trying to learn from their experiences. I think that Philip has brought a very interesting point that in order to best design this remedy, we have to engage in a participative proceedings and hear from the market participants, and also from companies what are the best design to implement this kind of remedies. And the Ministry of Finance report has emphasized it last year that CADE should use more the market investigation tool that we have under our Brazilian competition law framework. And I think that that's a very interesting perspective, because within this market investigations, and the UK has been a reference in the use of this kind of tool, I think that we could reach a better understanding about what are the main problems, the main competitive problems in sectors like mobile systems and ads, just to say the two sectors that the CMA has dealt in over the last years. So I think it's very unclear for us what is the best approach. We are, following and considering all these discussions and proposals.
Thank you, Victor. To complete this round, I would like to turn now to Dr. Chen. How do you see this issue?
Thank you, Leila. I think can you hear me? Okay. Because we don't have the ex-ante regulations, so actually we don't have any kind of remedy issues. I think the only remedy we have is probably in the merger case involving the digital company. And usually the remedy will be imposed in the form of non-discriminatory treatment. We don't impose something like interoperability, such kind of a more intervening remedy. So I'm not really in a good position to comment on the remedy and the public utility. But personally, I do have 2 points to make. I must emphasize this is my personal point of view, and not in any way represent the TFTC, because I think the name gatekeeper kind of carrying the tone of indispensability, and no wonder people tend to think this kind of DMA is a sort of the public utility regulation. I think it's understandable. But I think before we delve into the detail regarding whether connecting or associating DMA as a public utility regulation, we need to understand first the 2 preconditions that is traditionally justify the imposition of public utility regulation. The first one is, as we know, the public utility regulation is hinged upon the assumption that there is a market failure which could not be addressed by market itself. And back to the DMA, by imposing do's and don'ts, it actually equivalent to the per se rule in antitrust law. So I think, as most of you know, the per se rule is predicated upon the assumption that most of the conducts will be anti-competitive in nature. So before we impose the DMA style regulation, I think that's one of the beliefs that need to be verified by the competition authority or by the legislator, whether the market has demonstrated the trend or the feature towards the per se characteristic of the conduct. I think that's the first one. We need to have a more solid evidence or justification before we can do that. And the second one is again, I think the conventional idea about public utility regulation is based on the cost reduction consideration, because there is the natural monopoly trend. So we could only allow one company to operate. But in order to avoid the misuse of market power, we need to set a maximum standard to control the price. But I think that one of the questions that need to be elaborated upon is the digital market has shared a similar trait as the conventional public utility, especially when we take into account the innovation competition that is quite prevalent in the digital market. So I think that's a very, very different scenario we are talking about here. So anytime when we try to impose the DMA type or the ex-ante regulation into the market, like the digital market, that these are the 2 preconditions I always pop up to my mind. And I think, do we really have the evidence to support this kind of finding? Only when we have evidence can we say this kind of regulation will do good to the market competition. So that's my personal thought. Thank you.
Thank you very much, Andy. Alberto, would you like to reflect on the gatekeeper, either on the name or on anything you just heard?
Yes, sure. I think the gatekeeper name came because it's a fact. We didn't invent the name. I think we just named certain positions for what they are. And that is on the back in Europe of overwhelming evidence that this is the case. I would like to make just 2 very short points on regulation. The first is that we sent a debate, should the digital sector be regulated or not regulated? I didn't start my experience and career in enforcement in the digital sector, but one thing that really surprised me when I came to this one is that people ask these questions. Do you know any other important sector of the economy that is not regulated? Energy is regulated, telecoms are regulated, pharma is regulated. So what is so special in the digital sector that actually should not be regulated? I think there was something 25 years ago, 30 years ago. There was the fact that it was a new market and something that is completely new. I'm totally on board. Regulation is not very good at capturing new things, new trends, new effects. But now the DMA is not born based on that. The DMA was born based on 25 years of antitrust experience and enforcement in Europe, which indicated, for what relates to the European Union, that certain problems, certain issues are not isolated but are systemic. And that's where I think regulation has a role, to deal with systemic issues that have been proven over time. And that's why the DMA is very targeted. It has targeted very few companies. It targets a closed list of services, and it has very well specified obligations. And all these can be traced back to the experience we gathered through antitrust, sometimes merger control, but mostly antitrust. I fully agree that the DMA would be the wrong response to something that is new, something that is not yet understood. A certain type of practices that could be anti-competitive or not, take bundling and tying, their understanding the effects, whether it is pro-competitive or anti-competitive, is key. So I don't think you can regulate and saying bundling is forbidden, and indeed the DMA doesn't say that. But there are some things that, to us at least, in this market context, are so clear that there are ecosystems that are closed, that there are companies, startups, scale-ups that basically come every other day to say, I would like to do this, but it's not possible. It's not possible because I'm not complying with the rules of the one or two only possibilities I have to reach users. So this is why regulation is important in this context and in these markets. But I fully understand that what works in one jurisdiction may not work in other jurisdictions. And that's why we have very different approaches across the globe of agencies that all work towards the same objective. They take different approaches. This is absolutely legitimate.
Thank you, Alberto. I believe a lot of the concerns about the DMA are around the non-competition related goals, like the fairness and protecting smaller actors. So it's a little bit different in this perspective, how it's seen in other jurisdictions compared to the EU. Thanks so much for sharing your opinion about this. I believe Philip would like to join to this question, right?
Yeah, thank you. I was just going to say something about this utility point. I mean, one of the things I've noticed in the discussions, particularly in the United States, where they've engaged on these issues of pro-competitive regulation, is that many of the critics of it, unsurprisingly, many of whom represent illegally the large platforms, many of the critics of it say, look, this will just be like utility regulation. And their next point is that utility regulation has failed miserably in the United States. And therefore you shouldn't engage in it in such an innovative, fast-moving sector as digital. And yet I take Alberto's point. I mean, I've never seen a sector grow in such a way that if there's any regulation at all, it is just at the edges with respect to some of the most toxic harms. And even then, they've taken decades to be developed. And so it's something where I obviously ex-ante regulation is necessary. But I think this criticism that we're treating them like utility will stagnate their competitiveness. No, if anything, we're providing access to the gatekeepers for innovative new companies to test out their products and succeed on the competition on the merits. If they're locked out and that's how they lose because they didn't have the key, then that's not really a fair competition. So it's not the best metaphor, perhaps. But that was the idea we had in the UK. There's some aspects we need to unlock. We're not going to help or subsidize or push entrants in. It's just if they can get access to the data they need or the algorithmic processing power, and they can come up with a new business idea, an application for AI or whatever, then they should be able to, and not hindered by an inability to compete. So I think it's a very different idea from utility regulation, and therefore the harms are not likely to build up: institutional inertia, overregulation, regulatory capture. But I think intellectually, it is a similar situation. You're trying to find access to something that has become so important, so critical, so systemic, that you want to see innovation grow, and it can only grow, you think, from that, providing that access. And that also benefits us in terms of the fairness and the choice of products, etc. Thank you. That's all I want to say.
Thank you so much.
Let me just jump in, Lila, because I think this is a very interesting discussion. And as I was saying, I think that in Brazil, we have this first proposal, it's PL 2768. And as I said before, I think that it misunderstands the nature of the issues that we are talking here about competition in digital markets, because it may seems, as I said, large digital platforms as public utilities, but not seeing the kinds of harms and the kinds of preoccupations that we have been discussing here in the EU and in the UK, for instance. And I think that the most relevant distinction here is that, unlike public utilities, I think that platform power stems from deliberate strategic decisions rather than inherent technological limitations due by the ownership of a property. So that's the difference that some authors call ecosystem failures are different from market failures in the more traditional sense, because digital ecosystems operate in a non-linear value chain across multiple interconnected actors and not through vertically integrated infrastructure. And so I think that's the difference here, and that's the kind of difference that we should emphasize for legislators.
I think I have one point to make regarding the innovation and the regulation. I'm not saying that the regulation always are always inefficient. Actually, if we could have a very solid empirical evidence to support the need of regulating the industry, regulation truly offer predictability and clarity even for business to comply with the law. What I want to say is that for the industrial market, such as the digital market, I think it's challenging for the competition authority to predict the trajectory of the competition might lead the whole industry into. I will make a very recent example in Taiwan. We found that more and more people started using ChatGPT or other type of the AI software to conduct online search instead of using Google. So this is a type of dynamic competition I'm mentioning here. So each time when the regulatory agency or the competition agency try to impose ex-ante regulation to regulate the industry that is still under development and whose future trend or development is still not very clearly shown at this moment, I think we still need to be a little bit cautious.
Thank you so much, Andy, and to all of you to discussing this question. I would like to address you with the audience question we just received on Slido. And here I would like to remind the listeners to address any questions they want to ask from our speakers to send them on Slido. So can unforced sharing diminish innovation incentives? And what about the inverted U empirical literature that more concentration enhances innovation in some areas? This is the question we received from our audience. Who would like to address this?
But perhaps very briefly, this empirical literature, actually there is a theory behind, and the empirical part of it is not universal. As always in economics, you've got different studies showing different things. But I think there are two basic forces at play. One is competition that stimulates innovation, and the other is fragmentation that doesn't always help innovation. Basically, if you have many small companies, none of which has the capacity of investing and getting the returns from the investment on innovation, then concentration can help actually creating a minimal size or an optimal size to do innovation. So at some level, concentration will help innovation, and that's where the part of the inverted U that goes up. But also this literature and all the empirical evidence show that there is a point in time where the U actually starts going down. And that's where actually the concentration is reducing this effect of allowing more innovation, and actually is the lack of competition that takes over, and that's why innovation diminishes. So even under this literature, I think it really supports first the obvious thing that the monopolist does not have a lot of incentive to innovate, and also that an oligopoly or a tight oligopoly, 2 certainly, then 3, 4, that's a big debate, depends on the market, depending on the conditions, also may not be the sufficient number to have the optimal amount of innovation.
Thanks. I was just going to add that, I'm in England, and a joke that was made during Brexit is that the British like their cake and eat it too. And so, as Alberto indicates, even though the legislation here is pitched in a pro-entry way by pre-identifying problems where we think entry would be a helpful solution and a path to innovation, even though it's presented that way initially, and therefore through a democratic process supported by both sides or all sides of the political regime, they focus on pro-entry. Nevertheless, it's not completely an agreement that only innovation comes from small firms. It's basically saying we want the innovation of the big firms, and we're going to have the innovation of the smaller firms as well, because none of the PCIs, the pro-competitive interventions, are about expanding the number of firms, or reducing concentration in any ways. I'm relaxed if there's concentration down to 1 or 2, perhaps even 1, if there's enough access being generated to that platform. And so I think that's what I'm mainly focusing on isn't there a way, rather than arguing about the academic side of things, which I agree is mixed, that if the government has decided to introduce something that's pro-entry, then it's actually asking for both, because there's nothing in any of the legislation really that's about adding competitors. There's structural measures, but there's nothing about really adding competitors. It's not really an anti-concentration bit of legislation. Thank you.
Yeah, just adding some perspective here. I think that, as Alberto has said, there is this huge discussions in the literature coming from the Arrow versus Schumpeter debate. And I think that this literature at the end of the day says to us that it's very difficult to make some universal assertions about what is the best level of concentration for innovation. It's pretty much an empirical question that depends on several factors on each sector. But I think that when it comes to the discussions on ecosystems, and I think that Philip has said that in some way, it might depend on which kind of innovation are we talking about here. Is that the innovation from the complementors? Is that the innovation that can be prompted by the entry of new firms in these ecosystems and things like that? Or are we talking about the innovations by the gatekeepers itself, or by the orchestrators and these large ecosystems? And here, I think there are a lot of innovation force to ponder. And eventually, in the end of the day, I think that's a matter of political decision, a political choice to be made by the legislators on which kind of innovation should we want to foster, and which kind of innovation should we want to promote in our jurisdiction.
Thank you very much. Anyone wants to add something here on the forced sharing of innovation incentives or anything else? Okay, if not, then we move to the third and final part of our panel. The big question to our speakers is, what advice would you give to jurisdictions who are considering introducing digital antitrust regulations? As more and more countries consider whether and how to approach large digital platforms, it's increasingly clear that there is no one-size-fits-all solutions. As we highlighted in our recently published report titled The Policymaker's Guide to Digital Antitrust Regulation, jurisdictions must carefully evaluate whether regulation is truly warranted. Otherwise, they might risk introducing high compliance costs, chilling innovation, or triggering other unintended geopolitical consequences. As we found, some jurisdictions have moved quickly to adopt ex-ante rules, while others are still addressing whether new regulation is needed at all. And even among those countries where they were pursuing ex-ante approaches, models vary significantly in scope, in design, and in enforcement. So based on your expertise and experience, what advice would you give to jurisdictions who are still considering their options? Let's begin with Dr. Andy Chen. What lessons do you share from Taiwan's approach?
Okay, I think we don't have the ex-ante regulations, so my advice would be for those jurisdictions who are considering to follow the similar approach as Taiwan. I think I've said enough about the importance of connecting your enforcement with local nexus, focusing on local market, especially while at the same time pay attention to the international development. And other than that, I will advise that we probably need to pay attention to the level of digital technology development and the penetration rates of the digital technology in domestic market, because those both the technology development, digital market, digital technology may varies widely among different jurisdictions. Therefore, I think it's essential to consider those differences before enacting the digital competition laws. I think it all circles back to what I have mentioned, that because the future trajectory of the digital development is still not very unclear. So in order to reduce the enforcement error mistake, I think we better have some clear idea about the current technological development, the level of technology development in your own countries. So I think that's the additional advice that I could give to our audience if they are considering to follow the traditional approach.
Thank you very much, Andy, for that thoughtful perspective. Now let's turn to Commissioner Victor. Victor, drawing from Brazil's ongoing debates and your background in both enforcement and policy, what would be your guidance to jurisdictions still considering their path forward?
Yeah, thank you, Lila. As it occurs with Taiwan, we do not have any formal legislation in place. So I think that the most important thing to do right now is to follow the developments of these legislations in the European Union, in the UK, in Germany as well, and try to learn with their experiences. But I think that one important thing to be aware of is that the introduction of this regulatory regime, if it occurs, must be aligned with the institutional and technical capabilities of the regulator. And there is this huge debate in Brazil right now about who should be the regulator of ex-ante proposal, because, as I said, this first proposal that has been submitted before the National Congress assigns the legal power to the telecom regulator to set obligations to gatekeepers in digital markets. And on the other hand, the government proposal wants for that role to be played by CADE, by us, who are the competition agency. But I think that no matter who's going to be the regulator here, I think that for smaller chains like the Brazilian Competition Authority, it's important to ensure some flexibility in the procedural management and to give some discretion to the regulator to define priority sectors. And I think that we should first look and we should first focus on sectors with the most significant competitive bottlenecks, which might go beyond than just seeing the size of the firms, So I think that's important to map out through market investigations where are the main priorities for the Brazilian economy in the first moment. But of course, that depends on several factors on how this legislation will assert the quantitative and qualitative criteria, for instance, for designating terms. That is a still open question. But I think that we should keep in mind our capabilities as regulators and try to fix and to align that with the goals of the legislation in place.
Thank you so much, Victor. Philippe, what principles do you think jurisdictions should keep in mind if they are considering ex-ante regulations?
I think the main thing is that even though you're aiming for an ex-ante regime, anything of any real importance is going to be litigated aggressively, and which will delay the market impact and the market benefits. So that's, we're seeing whether it's with respect to designation or whether it's with respect to any of the obligations. So that has to be built into your for example, argument to the government that you can do things faster. That's part of the argument. It's a litigation risk. Number two, relatedly, resource strain. So the authority handed to these powers, in the UK it happens to be CMA, will be relying, a lot on the other regulators. They have a coordination forum where they'll be, working with the privacy, with financial services, with telecoms to try to identify which are the most, proportionate and yet effective remedies. And finally, I guess the issue will be global coordination on a lot of people's minds right now. And all I'd say there, and I would as a good Canadian, I suppose, as well as a European, I think of myself still, is that regional associations, regional groupings are going to be able to help. So if an authority doesn't have the resources or ability to engage in this regard, then clearly a regional approach would be better. It's just any opportunity to have some kind of input into the changes that are being made in your own market, even if dictated from some other jurisdiction, I think is only fair. And so if it's the degree to which there's some coordination, even if it's only with respect to the companies, that you say to them, look, we see you're about to implement a European Commission order, you're going to do it globally. Well, we have some views, but it's not going to affect the Commission's order. It just might affect the implication or the implementation in that jurisdiction. I think we'll see arguments about that. But thank you for the opportunity to join this call. It's been fantastic. I love hearing what everybody has to say.
Thank you so much, Philippe. Last but not least, I would like to ask Alberto, what insights or cautions could you offer to jurisdictions who are still designing their regimes?
But it's, I think everything has been said, and I fully agree with what Andy, Victor, and Philippe said. I think there is no magic formula. There is nothing that has to be in a specific way. The European Union, for some reason, went first. It's a possibility. It's an example. To the extent that we succeed, it's probably a positive example. To the extent that we make mistakes, it's also something to learn how to avoid. But to me, the core of the question is not even legislation ex ante versus ex post enforcement, is what we are trying to achieve. And if there is a thing that is very close to my heart, doesn't really matter what regime we have in our respective jurisdiction, but it's very important, as Philip said, that we discuss and we coordinate globally, because the companies we deal with are global and they know way better than we do the situation all around the globe. And so it's very important that we collaborate. I don't see an obstacle to collaborate with jurisdictions that don't have ex-ante legislation. It's quite striking. In the US, there is no ex-ante legislation. Let's look just at the ongoing trials towards big tech companies. What the agencies are bringing there, or the state attorneys are bringing there, is something we are trying to achieve in Europe with the DMA. So we have the same goal. We have each one on the different way. We have all our constraints in resource, in skills, in budget, in market size. There are so many factors that come in. I think what is really key for me is that we have common goals and that we really bring them together to these companies.
Thank you, Alberto, for pointing out how interconnected these issues are. As we are getting close to the end of our panel discussion, I would like to wrap up by asking each of you to just say one sentence, like one takeaway sentence. We should start with you, Alberto.
I'm totally unprepared for the takeaway sentence. Just to take the opportunity to thank you, Lila, and all the speakers, because it's been a very interesting debate, and certainly there will be more of that.
Thank you. Thank you as well. Philip, I give the word to you.
Yeah, sorry. One sentence with 3 hashtags. Hashtag evidence matters. Hashtag A/B testing remedies matters. And hashtag interoperability stimulates competition. These are red hot hashtags, I can tell you.
Thank you. Very fancy. I would like to give the word now to Victor.
Thank you, Leila. Just want to thank you for providing this platform for us to exchange our experiences. And I think that's a very important thing that we should do. And so far, talking with people from other jurisdictions to learn with their experiences. Thank you.
Thank you very much. And finally, last but not least, Andy, any hashtags?
Thank you, Lila, for giving me the opportunity of conducting the final say. I think the DMA offer great clarity and predictability to business community. Still, it is advisable to assess the strengths and weakness of domestic markets in comparison to those of other countries before deciding to adopt ex-ante regulation. I think that's my sentence.
Thank you very much for all of you for your thoughtful messages. Today's discussion has been very thought-provoking and made it clear that while there is no universal solution to approach digital platforms, the global dialogue is pretty rich, and we should continue talking about these issues. Thank you again for our panelists to be here with us and everyone who joined us today. I encourage our audience to stay tuned for future events, and I wish you all a great rest of your day.